Hello, my name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, from the previous video, we have started to cover the Labor Union and Labor Relations Adjustment Act. And today, with Labor Attorney Jung Bong-soo, please explain more detail about the definition of Article 2.
Okay, hello, how are you today? This is Bong-soo Jung, Korean labor attorney. So there are some definition of certain terms like work, employer, also labor union or labor strike or kind of industry action. Those are the terms stipulated in this Labor Union Act. So today, especially I like to talk about employee. So what is the meaning of employee in this Labor Union Act? So to explain the employee in Union Act, we need to know what is employee in the Labor Standard Act. So usually Labor Standard Act is based on individual working relation with the employer. So to be an employee in the Labor Standard Act, employee should have some job or a workplace where they provide labor service intensively to the particular employee. So based on employment contract, employee provide the labor service, then employer pay wages. So in such a relation, we call it employee according to the Labor Standard Act. However, Labor Union Act, the employee means those people who are living based on income or wage, so without any relation with a particular employer. So for example, the employee in the Labor Standard Act means those people who earn their income or wage from particular workplace. So this means without individual the employment relation, those people who are earning by providing their service or labor, then in return for that they earn the income or wage. So those people can be a wage, the employee. So employee in the Labor Union Act means they are entitled to making labor union. So labor union have a right to the bargain and negotiate, and they can conclude a collective agreement. Also, in case there are labor dispute, then they can go on strike in order to get a better the collective agreement to improve their working conditions. So basic difference is like work employee in the Labor Union Act has a bigger meaning. Like of course employee include already the employee in the Labor Standard Act, but also it includes those people who are earning the income or wage from the workplaces. So that means the employee in the Labor Union Act has a bigger meaning. So it can contain even unemployed employee or those employee without a particular employment contract. Yeah.
So based on your explanation, it's like the Labor Union Act, under the Labor Union Act, even they are not employed by the employer in an organization, they can form the labor union. Is that right?
Yeah, that's right. Yeah. For example, the partial delivery people, they work independently. So number of their package they are delivering, they can earn the money. So but they are free to deliver in any time. So also they are not engaged in employment contract, but they are engaged in service contract. So, but they could earn income from those some main service companies. So we call them, they are kind of individual employer or some service provider, but those people, they are earning money by providing their labor services. So those people can be employed. Also, they can authorize to organize the labor union. So that is kind of employee in the Labor Union Act. Yeah.
So in case this independent workers without the employer, they form a labor union, and who are they? If they want to retain their right and fight against some disadvantage, who are their counterpart? Is it?
Yeah, I think for example, so like for example, CJ, the package delivery company, they have some the branch offices. So branch office, they have a direct contract with the partial delivery people. Then I think CJ didn't have any the direct employment relation or service relation with the partial delivery the people, but still the group of partial delivery people, or we call partial delivery labor union, they ask some CJ company for collective bargaining. They, in that case, CJ company can control their working condition for like the price, the price for delivery fee. So in that case, CJ company should be an employer who can respond to collective bargaining. And so this is how relation is like this one. So like employment culture or labor standard, it is very clear who can be an employer and employee, because they have employment contract. But Labor Union Act, there are no employment contract. But how they earn very exclusively from certain the channel like CJ, but in the middle of the delivery service people and CJ, there are some branch office. So branch office they control directly, but the partial delivery labor union, they can ask collective bargaining to CJ company, because CJ company is controlling economically for those the delivery pieces. So this is how it's going. Yeah.
So it's like an outsourcing company of CJ.
Yeah.
In the middle.
Yeah. So some
subcontractor.
Yeah, subcontract, kind of subcontract can make their own labor union, because they are individually working to earn some money. So if that is a subcontractor, like the corporate entity, but it's not allowed, but it should be individual people. So individual people earning through CJ some delivery services. So even though between delivery people and CJ there is some branch divisions of branch entities, but they are controlled directly by the CJ company. So those delivery service union can ask directly for collective bargaining to CJ company. So even court agreed with who can be a bargaining partner as an employee. So they like CJ is accepted as the bargaining partner or employer. Yeah.
I see. Thank you very much for your detailed explanation, and I look forward to covering the Labor Union Act.
Yeah. If I add more, like employee in the Labor Union Act has a bigger meaning, including the employee in the Labor Standard Act. Yeah. So maybe through this video explanation, I'll explain some more about their role in some definition of the employee in the Labor Union Act. Yeah.
Thank you very much.
Okay, thank you for watching. Bye bye.